Hello, this is going to be a very quick lecture on how to answer question 5 from the Zone B 2019 exam paper. It's a trademark question involving Ostrum Ltd, which is a glassware manufacturer, and its trademark CLARITEE. The same company and the same trademark appear in the Zone A paper for the same year, but the problem's different, so I'll get to that some other time. If you haven't already, go and get the exam paper, which you can download from the VLE, so you've got the wording of the question in front of you. Now you've got it, the first thing to do is to look through quickly and see what signposts the examiner has put in the question. Are we bothered, for example, about the name of the company? Well, highly unlikely. Does it matter that it makes glassware? Potentially, because that should limit what its trademark's protected for, and that could be important if there's a question about infringement but somebody's using it on other goods, and it might also be relevant to revocation because it could be relevant to whether the trademark has been properly used. We might also need to ask whether, given the nature of the goods, the trademark itself might be regarded as descriptive, or possibly even devoid of distinctive character, or in the worst possible case, not even a trademark, completely incapable of distinguishing goods and services of one undertaking from those of others. Okay, so the fact that they make glassware may be relevant. In 2003, 16 years before the exam, what time periods are relevant in trademark law? Well, 5 years non-use for revocation purposes is important. A few years use if you're going to have to rely on acquired distinctiveness could be important. And 10 years from registration to renewal could be important as well. So we've got a long enough time period for all those elements to be relevant, perhaps. What do they call their new range? They call it CLARITEE, which looks like it's been cunningly designed to sound like clarity, but not to have a Y at the end, but a double E. I suspect that for most people involved in making glass, clarity is a highly desirable quality. Glass that you can't see through, glass that isn't clear, has its uses, but probably for glassware you want to be able to see what it is in the glass that you're drinking. So here I think is the first signpost that the examiner's given us. It's potentially a descriptive trademark, and we might therefore be talking about absolute grounds for refusal of registration, or the same grounds being used on an application for invalidity. Right, the new range quickly became Ostrum's biggest selling product. Well, we don't need to know about that, unless perhaps there is a question about whether it's going to have a sufficient reputation for dilution remedies to apply to it. But the straightforward observation that it's the biggest selling product doesn't really get us very far in deciding whether those provisions are going to be applicable. To make this glass you need a special chemical called magunium, and the only place you can get that is from the Isle of Stark. Okay, where it comes from is not relevant, but the fact that it's pretty rare definitely is, and you might be able to see where the examiner's heading with this. If the examiner tells you that the trademark owner needs something specific in order to make the products that they're applying the trademark to, you can be pretty sure that supplies of that stuff will have been interrupted somehow, and for that reason the trademark will have fallen into non-use, and if that non-use has gone on for 5 years then it's vulnerable to revocation unless the interruption to supplies constitutes a proper reason for non-use. So we have to park that for a moment, because the examiner now tells us that Ostrum have registered the trademark in 2010. Remember, this is a 2019 paper, so it isn't yet up for renewal. Strictly speaking, we should ask whether the application was made in 2010, because that's going to be the starting date for the 10-year period before renewal's due, and all we're told is that it's registered in 2010. So we don't know whether that's the actual date on which the registration was granted, or whether it's the application date from which protection runs and from which the 10 years for renewal runs. But anyway, let's just make a mental note that if we've got time at the end of the question, we might mention that to the examiner just to show how clever we are. It was registered on the basis that it had been used extensively for the previous 7 years. so that means it had acquired distinctiveness. That overcame any objections that the registrar might have had on the basis of the trademark being devoid of distinctive character or otherwise descriptive, or possibly generic. I don't think that's going to be an issue. All those issues under section 3 subsection 1, which can be saved by acquired distinctiveness. But don't forget that the more fundamental absolute ground for refusal, that the trademark simply doesn't fall within the definition of a trademark, could still be relevant. Could it be said that this trademark simply is not capable of distinguishing Ostrum's goods and services, well, goods in this case, from those of others? So I guess that's not really a signpost in the question, but it is an issue that perhaps we're going to have to return to. Next, the examiner tells us that the island where this famous chemical comes from has been destroyed by a volcanic eruption, so there are no more supplies of the important chemical, and consequently Ostrum haven't been making any CLARITEE branded glassware since. So on the face of it, the loss of their supplies is going to be a proper reason for non-use of the trademark, but it is going to be necessary to ask some further questions. They've been making this glassware since 2003. In that time, have they found a substitute for Magunium? And have they actually been looking since the eruption in 2011? Or did they just sit back and say, well, that's that then, no more CLARITEE glass? There's a strong second-hand market in CLARITEE glassware, which may or may not be an important issue. Obviously, Ostrum Ltd aren't actually selling anything in that market. Presumably stocks of new ones have long since disappeared. And anyway, that's not what the examiner's telling us about. And it's not as if there's it's not like a strong second-hand market in motor cars, for example, where the manufacturer might not be making the cars anymore, but might well be selling spare parts and services. You don't need that sort of thing for glass. So Ostrum are asking you if they should oppose these 3 applications, and it seems to me that in each case the trademark would sound like CLARITEE, so it would be exactly the same as their registered trademark, but in each case spelt slightly differently. First one for toilet cleaning products, the second one for teacups, the third one for windows. So the issues are that we have a trademark owner with a weak trademark in that it's rather descriptive. It only got registered on the basis of 7 years use, and while the examiner may have been convinced by that, it's quite possible that a court will see things differently. Moreover, it hasn't been used for much more than 5 years, so it's vulnerable to revocation, but it's possible that we have proper reasons for the non-use. Then we have the 3 potential oppositions, which Ostrum shouldn't be bothering about at all if their trademark is really vulnerable. But assuming that we get over that, we need to analyse those 3 potential oppositions, applying the famous triad of protection, so double identity, and then identity or similarity and likelihood of confusion, and finally reputation, unfair advantage, and other detriment. It's worth pointing out that this is in no way an infringement question, but of course because it raises issues about opposition, then many of the issues which would arise in an infringement question are engaged. But as you must be aware, the examiner never asks just about infringement or just about opposition. They'll always throw in something about revocation or invalidity. So you have to watch out for the signposts that point to those issues. Start off by telling the examiner that you've recognised what the question's all about. The owner of an earlier trademark can oppose a later application where there are relative grounds for refusal on the basis of the earlier registered trademark. But note that the later applicant will be able to put the owner of the earlier trademark to proof of use if that earlier registered trademark has been on the register for more than 5 years. Ostrum should also be advised that with a descriptive trademark like this, they may well find that attacking somebody else's application prompts that other party to make an application for a declaration of invalidity of Ostrum's trademark, which would be on the grounds that, well, one of the absolute grounds of refusal in Section 3, subsection 1 of the Trademarks Act applies. And what will get you over the threshold to a first-class answer, I think, might well be to say that by the same token, Ostrum could be arguing that these 3 new trademarks are subject to the same objections. They're descriptive, or they're devoid of distinctive character, or whatever, and we're not told how much use they have behind them, but Ostrum had 7 years use for clarity when they applied to register it. If these new applications don't have a few years use behind them, then perhaps they should be refused on absolute grounds. So moving on to the next point, is there a danger that Ostrum's trademark could be revoked on the grounds of non-use? Because if it would be, they'd probably do well to keep quiet about these new applications. In fact, I think if this was a client of mine, I'd be saying to them, look, you've got to pay renewal fees next year. You haven't used the trademark for a long time. Is it really still worth it? But I'm not sure the examiner's going to give you any marks for that. So work through what you know about the requirement for genuine use. Mention the Ansell case. Ansell is one of those kind of top 10 trademark cases that you should work into an answer. Does the existence of a second-hand market help? Can the case be distinguished from Ansell on that basis? Are there proper reasons for non-use? Well, you're going to be arguing, of course, that the volcanic eruption is a proper reason, but you do have to inquire about Ostrum's efforts to overcome the problem and perhaps find a substitute. If Magunium is so great in their product, what do their competitors use? Is there any good reason why they didn't go down the same route once they couldn't get any more Magunium? Because that's going to call into question whether they've got a proper reason for the non-use at all. So I think that disposes of the revocation point. You then move on to the relative grounds for refusal, which is what you're going to be arguing in opposition proceedings. You need to be systematic about how you approach this part of the question, but you can choose whether you analyse the signs themselves first and then the goods involved, looking for identity and similarity and considering likelihood of confusion where necessary, or whether you deal with A, then B, then C. I suggest for this question, on the basis that the trademarks are all pretty well identical, or at least the same issues are going to arise in relation to each of them, then deal with the trademarks first. And don't overlook the possibility, on the basis of the LTJ case, that the judge would regard the trademarks as identical because the differences between them are so minimal. Don't tell the examiner that and then just move on, though. Tell the examiner that and then consider the rules about similarity, because I'm sure that's what the examiner wants to hear about. Look at those words visually, consider them hourly, and consider them conceptually. Remember that the first part of the word is going to be more important than the end of the word when it comes to a visual comparison. So I think visually, certainly the first two are very similar to the client's registered trademark. What that rogue full stop in the third application does is not clear. It's certainly not as similar as the first two visually. How it works hourly. Do you pronounce that CLARITEE perhaps? Well, I think you need to tell the examiner that maybe there are some additional differences when you compare those trademarks hourly, but certainly the first two just sound like CLARITEE. Conceptually, well, it looks to me as if each of these applicants has tried to find something that conveys a sense of clarity without actually using the word. I think they'd all do well to go and hire some brand consultants to help them, but that's certainly not something that the examiner is going to be bothered about. So we've got the possibility that they'd be regarded as identical, strong possibility that they'd be regarded as similar. Is there a likelihood of confusion? What would the ordinary consumer make of all this? And then moving on to consider the goods concerned. Are any of them similar, well, first of all, are any of them identical to the glassware for which Ostrum has got the trademark registered? Definitely not. Are they similar? Well, I don't think there's any way that toilet cleaning products or teacups would be regarded... hang on, well, toilet cleaning products certainly wouldn't be regarded as similar to glassware. Teacups have similarities in that you drink out of them and you put them on the table at meal times, but on the basis that you drink different things out of them and they're made from different materials, I think there are grounds for saying that the trademark, the goods would not be regarded as similar. They're not really substitutable for each other. So applying the criteria set out in the cases, the test for similarity of goods or services is set out in the Canon case, where the Court of Justice said all the relevant factors must be taken into account, including the nature of the goods, the end users, the method of use, and whether the goods are in competition with each other or are complementary. On that basis, you might find a lot of similarities between glassware and teacups. And finally, you need to apply the global appreciation test. Here, the senior trademark has been used quite extensively, which, as far as the court is concerned, means there should be a greater likelihood of confusion. And that means that you can tolerate a lesser degree of similarity before there's a problem, at similarity of goods. So the closer the trademarks are, the further apart the goods can be. You sort of compensate one with the other. I don't think it's going to make any difference in this particular case, but the examiner is going to want to hear about it. When you come to apply the Canon criteria to the third situation, the windows are made of the same material, or basically the same material, but I think there any similarity ends. So on the basis of your analysis, you're probably going to be saying to the examiner, well, we don't need to worry too much about the teacups, perhaps. They look as if they're similar. But the other two situations, you're going to have to look at section 5, subsection 3. And actually, for the sake of the exam question, you're going to apply section 5, subsection 3 to the teacups as well. Does Ostrum's trademark have a reputation? Would the use of these later applications without due cause, important words to mention because they're in the legislation, even though it's very hard to work out what they might mean, would they without due cause take unfair advantage of or be detrimental to the distinctive character or repute of Ostrum's trademark? So what you need to do is to apply the criteria which are set out in the module guide, and although there are no marks for being right or wrong about this, I think probably indicate to the examiner that you've got some appreciation of how this is going to turn out. The first thing to wonder about is, as I mentioned earlier, have all these years' use of the trademark by Ostrum created enough of a reputation for section 5.3 to be applicable? Have they got something to protect? Assuming they have, are any of these proposed new trademarks going to do anything detrimental to the distinctive character or repute of the trademark owned by Ostrum? Well, being associated with toilet cleaning products is not desirable, but it's hard to see how it's detrimental. Teacups and glass, I don't think, would be detrimental, but I think it's fairly clear that putting the CLARITEE trademark or a similar one on teacups is taking a bit of a free ride on the reputation that the glassware has got, and it's quite possible that consumers would assume that windows, which have got a CLARITEE brand on them, contain glass made by the same process as that used by Ostrum. So there's, on the face of it, a strong likelihood of there being some unfair advantage involved there. One final point on reputation, which is the threshold condition for the application of section 5.3, which I should have mentioned earlier. They've got all this use, but of course they've got many years of non-use as well. So although on the face of it the trademark's old enough to have a reputation, has that reputation been lost because of the non-use since the volcanic eruption, such that section 5.3 won't help here? Or are they actually saved by the fact that there's a flourishing second-hand market? It doesn't help with the question of non-use for the purposes of revocation, but it may well help for the purposes of a reputation when you're applying section 5 subsection 3. So there's probably a lot more to this question than meets the eye. and a lot of points there which, if you're able to identify them under exam conditions and write something about them, could easily get you from a sort of modest 2-2 answer up to even a first one without too much difficulty. Hope that's helpful. I'd be very grateful if you'd leave comments if you found it helpful. If you haven't found it helpful, then again leave comments, because that will make sure that the next one's a bit more helpful. Watch out for new presentations in this series, and good luck in your exams when they come.